number 65, City of New York versus Maul. Good afternoon, Mr. Colley. Do you wish to reserve any time for rebuttal?
Yes, Judge Park, we would like to reserve 4 minutes for
4 minutes? Okay. You may proceed.
Thank you. May it please the Court, Drake Colley for the City of New York. This Court should decertify the class because certification was improper. In spite of extensive litigation and disclosure of ACS's policies, procedures, and practices, interveners have never identified even a single policy, practice, or procedure that violates the laws on which they bring this case.
Well, there was testimony from somebody, I think it was ACS, that said, we put these people on hold or something and wait for OMRDD to do something, and then if they don't do it, we take them off of hold. And it sounded like even in some of the depositions that the two barely spoke. And at least when you approach the policy points of view, it seemed to me there were some things that ought to be addressed that don't affect simply these dozen people or so, but that affect the policies and practices of the two organizations. Am I reading it wrong?
I would say so, Judge Big. And the reason I say that is that, first of all, we're looking at snippets of testimony, disparate, and I can make the representation to this Court that, yes, ACS and OMRDD are in communication. They were in communication before we initiated this lawsuit. They've been in communication throughout.
Are these 11 individuals who were the original plaintiffs in this action, have they all been placed now, or are some of them still on waiting lists?
I admit I asked that question.
Or have some of them aged out, I presume, as well?
Well, there were some of them that were actually aged out, but ACS continued to keep them in their care despite that. I asked the question actually last week, and I didn't bring my notes with me. My recollection is that at least 10 of them have been placed, but I wouldn't want to make a misrepresentation to the Court as to whether or not that's accurate.
Can I ask you why we shouldn't take an approach like the Third Circuit did in the Baby Neal case? I mean, there's obviously some kind of systemic difficulty. It may be a lack of resources, it may be a lack of evaluation, but there seems to be some legitimate concerns raised here, for sure.
There may be legitimate concerns, but we take issue with the notion that there is a systemic problem, and the reason that you would distinguish Baby Neal coming out of Philadelphia is that they pointed to a specific statute that was being violated. That's exactly what we don't have here. They've never yet pointed to a specific statute or a specific regulation. What they've done basically is they proceed on...
There's a statute that says these people are supposed to get treatment, right?
Yes, there is.
And suppose there is a systemic failure. I mean, you say there isn't, but I assume that's in dispute. Should we then, is a class action the right way to deal with that?
A class action under the facts of this case and under the definition of class that was proposed by interveners and accepted by the Supreme Court, no, because the class
is that because you need an individualized inquiry for each child?
Yes, Your Honor. The class is unworkable because you can't even determine who is in the class without going into a very fact-specific, intensive investigation of each individual to find out whether or not they were entitled to services, whether or not they received those services, if in fact they were denied, why they were denied.
So you're saying this is more like the Mitchell case?
It's absolutely like the Mitchell case, and I would take it further to say that individual determinations as to each intervener would not be common to the class.
Well, what about Klosterman v. Cuomo? That's a similar situation to this, is it not?
It's similar in certain regards, but we, once again, rely on Mitchell. We think that that's because you can't really even figure out who the class is going to be without doing an inquiry. I'd also like to, I know the white light is on, so I would like to also very briefly touch.
Could I just ask you so we get some global idea how many children we're talking about that would be somewhat comparably situated?
Well, interveners had placed the figure at somewhere around 150, but once again,
That's why I was asking you. I didn't know if that was what your agency felt was also the size of the group that perhaps is affected.
well, I don't know that the agency has actually even set forth a number that it feels would constitute the class, but I do know that interveners, at least my recollection, is they place it at somewhere around 150.
I had another question on how this process works for identification and evaluation. Are you doing the evaluation and the placement, or does OMRD do the placement? How is that coordinated between the state agency and your agency?
Yes. The ACS does an evaluation, and based on their determination, they make a reference to OMRDD.
They're supposed to
and
send
it's
a
up to
file
OMR.
and material to OMRDD, is that it?
They send a package to OMRDD, and OMRDD then takes a look at it, and they...
So is it a problem that we don't have OMRDD here as well? I mean, are you claiming it's OMRDD's responsibility to place these children, or is it ACS's responsibility?
It's ACS's responsibility to refer them to OMRDD, and once, of course, they're accepted by OMRDD, and once the family court signs off on the permanency hearing, then that's it for ACS. But
They're saying you don't do your job, that the packages aren't complete in some instances, and they're late, et cetera, that ACS is part of the cork in the bottle in getting these things done.
Well, even if, in fact, you accept that that may occasionally happen, that there might be a difficulty with a packet, that doesn't necessarily mean that that class certification is correct. In fact, how do you even determine, without taking a look at the individual situation, whether
Because
that
if you got
was, in fact, a
150
problem?
people and 75 of them aren't getting taken care of timely,
I'm sorry, Judge.
I was just saying, if you got 150 in the class and 75 of them aren't getting timely service because ACS and or OMRDD aren't doing their job, it would be better to simply say, what's the problem with the process, rather than saying what happened to AC and DF, et cetera.
And I would respectfully submit that that's where the family court steps in, because there's, under the new Article 10A that went into effect on December 21st of 2005, the family court has an enhanced ability. They take a look at this situation every 6 months. There's
Right,
not
and
a
they make
single-
sure that all statutory obligations have been met by the agencies, correct?
I'm sorry.
They make sure that your statutory obligation has been met and OMRD's obligation has been met also.
Yes, Your Honor. That's what they do.
All right, you still have your rebuttal time, counsel. Okay,
Thank you very much.
thank you. Ms. Williams?
So what is the problem if family court is doing these evaluations every 6 months? Where's the bottleneck?
Family court doesn't review the claims that the class members brought here every 6 months. And there are several reasons that the court below that the family found that the family court is an inadequate forum. Family court does not review the ACS practices that lead to children being placed in inappropriate placements or not receiving the services they need. So ACS, or
So what are they reviewing? They're reviewing foster care placement. What are they reviewing?
they're reviewing whether progress has been made to achieve an individual child's permanency planning goal.
And what do you want the courts to review?
We would like
That is the courts other than family court.
We would like the courts to review whether ACS has failed to meet its statutory obligation under state and federal law to provide appropriate services in the most integrated settings, rather than...
Is that the narrowest common issue you can state, whether they've done their job?
There are narrower common issues that the court below raised.
Narrower
such as-
issues common to the whole class?
Yes, that deal with...
What's the narrowest you've got?
Well, for instance, the specific issue of whether ACS has failed to adequately ensure that the staff who are responsible for identifying children with developmental disabilities and referring them to the state understand what a developmental disability is and
The
make sure
training,
that happens.
the quality of the staff?
Well, the training,
The training, is that really common to every class member has an inadequately trained, is suffering from inadequate training by the...
yes, Your Honor, because a failure to ensure that everyone is adequately trained is creates a risk of harm for every single child who's in the foster care system.
Well, the Tenth Circuit had a very similar case that came out of Nevada in that JB case, and they came to a contrary conclusion. So I guess we're trying to figure out what is the specific common question of law that you're seeking certification for. Because to just say these children aren't receiving proper services, that's hard for us to direct in a writing what the trial court is supposed to examine.
Two things, Your Honor. First, with regards to that Tenth Circuit case, there's a very recent Tenth Circuit decision that came down last month that we cite in our supplemental brief, where the Tenth Circuit says, you know, that JB case is distinguishable because the children there, various class members had claims against many different agencies, and there was no plaintiff who had a claim against all of the agencies in question. In this recent case, Strickland versus Devon, the question was, do all children in the Oklahoma foster care system suffer from the failure of that system to ensure that adequate monitoring is in place to make sure that the children don't suffer further harm in foster care? And the Tenth Circuit said that question, which is about the failure of one agency to make sure its practices are sufficient to ensure that the children aren't harmed, that is proper for class treatment.
So if we agree with you, what are the issues you are asking us to direct the trial court to consider, besides staff training, the adequacy of the folders or the evaluations?
Well, there are really two separate issues, which goes back to how this litigation arose, which is that the city sued the state, saying that the state needs to provide for the specialized needs of these children with developmental disabilities. So one question is the city doing its job in identifying children as eligible for these services and ensuring that they're found eligible by the state?
Suppose you win, they have a trial, and you prevail on that. The city's not doing its job. So what do you get? You get an order saying go do your job?
Well, as this Court explained in Klosterman, yes, declaratory and injunctive relief would be very important.
But in Klosterman, you had a statute that said you've got to have plans for these people. And the agency was not giving them plans. You don't have a statute that says you have to train particular workers in particular ways. You don't have a statute that says you've got to coordinate in a particular way. This is a real systemic failure case. I'm really asking, suppose you have a systemic failure. Suppose there's an agency that is completely broken down. How does a court fix it?
Well, there are specific statutes in place, the Americans with Disabilities Act, the Rehabilitation Act, and the New York Social Services Law, which say specifically children need to be provided with appropriate services.
And I can understand that a court can say this child's not getting what he or she is entitled to give it. But when you have a systemic failure so that the system set up to deliver the services doesn't work, how is a court supposed to make it work? Do we order more money put into the system? Do we order a head put above these two agencies and bash their heads together so they work together? What do we do?
Well, I think declaratory relief would be very meaningful in this case because the city and the state are both pointing at each other and saying the other is responsible.
So we issue a declaration saying you're both responsible, that fixes it?
That's not the entire relief we're seeking.
Can we order anything about OMRDD when they're not a party here?
They are a party below. They just didn't appeal the class certification decision. So the class still has a class action against OMRDD.
Are they defendants on the class claim?
Yes, there are class claims against OMRDD.
I mean, I take it what your ultimate goal is some kind of a consent order. Is that what you're trying to achieve?
Well, that's usually how these cases have ended up being resolved in practice. But what we're really asking for is something very similar to what ACS has asked for the court to order against the state in its own litigation against the state. In ACS's prayer for relief, for example, they asked the state or the court to issue an order that OMRDD put in place a procedure to ensure that all children who are properly referred receive a placement in a reasonable amount of time. That's the order ACS is asking for, and we would ask for a very similar order.
Could you elaborate on the waiting list allegations that you have here? Because is that a problem of there's not enough programs for these children or not enough residential placements? Is it your waiting list or OMRDD's waiting list? I'm trying to understand those complaint allegations.
The waiting list is a term that ACS uses for children who have been found eligible for adult residential placements by OMRDD but have not yet received those placements. Of course, under federal and state law, ACS is still required to provide appropriate placements in the most integrated setting to those children while they're waiting for a placement from the state. So the wait list is really a group of children who the city itself alleges are not currently receiving the appropriate services.
Okay, so if
and
the answer
placements.
is there's no vacancies, there's no spaces, then what does the judge do?
Well, first of all, we don't know that that's the answer.
I know, I'm just posing it as a hypothetical.
The judge could, I suppose, order more spaces be created. That's what happened in the recent case of Disability Advocates versus
So there's a
Patterson.
funding aspect to the litigation as well.
It's not necessarily a funding aspect, except insofar a question of whether the city is going to pay for it, or whether the state's going to pay for it, or whether Medicaid's going to pay for it.
You can't create new places without money.
That may be. And the court in Disability Advocates actually found that less restrictive placements are less expensive. And further, there's an issue of services, which is that some children, if they had been receiving appropriate services all along in foster care, would not necessarily need as specialized or expensive placements further on down the line.
How can a court, why is a court better equipped to make these decisions than the professionals, no matter how bad a job they're doing? I mean, I understand that these agencies don't seem to be working well. What does the court offer? Is the court smarter? Is the court going to work harder? If the agency can't do it, how's the court going to fix it, other than saying spend more money?
The problem is that the agencies aren't doing it, and this court has made perfectly clear in Klosterman and Jiggets that when the legislature says services need to be provided and agencies aren't providing the services, plaintiffs have a right to sue and to seek declaratory and injunctive relief, ordering that the services be provided in accordance with the legislative mandate.
Is that a general proposition every time? Every government agency in the country that's generally doing a bad job can be sued in a class action to say do a good job?
Here they're doing a specific bad job that violates both state and federal.
Well, every agency has a purpose. Every agency has an obligation. It exists for a reason.
Yes, Your Honor, but in this case, the legislature has directed that they must meet a certain standard, which is to provide placements in the most integrated setting, not in nursing homes where some of these children live for years, not in psychiatric hospitals where some of these children live for years. And if the agencies violate the law by failing to meet the standards the legislature has established, then the plaintiffs are entitled to relief.
What are the service settings? What type of services are we talking about here? Are you looking for community residences? Are you looking for specialized treatment facilities? Or primarily additional services while they're living in a foster home? Or is it across the board, all three?
Well, it is all three, and it could be a range. I mean, the state already has developed a wide range of placements that are appropriate for people with developmental disabilities that are, as integrated in the community as possible. And the issue here is really that the city also needs to be able to provide that type of placement. They can't just rely on the state to do it, because they're obligated under the law to provide those placements to children while they're in foster care if the state is not doing so.
Okay, thank you so much, Ms. Williams. Mr. Colley, the rebuttal.
The services that these individuals require are as varied and as different as the individuals themselves.
Well, one of the points that's made, I think, that was just touched on, is that the plaintiffs argue that it's ACS's job to provide specialized services to foster children. And ACS says, no, it's OMRDD's job. And OMRDD says, no, it's ACS's job. Now, it seemed to me that that's something that ought to be resolved, and if it can't be resolved between the two, then perhaps it ought to be resolved judicially.
And in fact, that might be the reason that we're here in the first place, because ACS did bring an action against OMRDD. But
What was the result of that action? Again, what was the result of that action?
I'm sorry?
What was the result of that action? What
That
happened?
action's still pending.
We're
We're here now to determine whether or not interveners should have been granted class certification.
But the point, I mean, the QED then is that if we're going to decide that issue, why not decide it for all people similarly situated?
And that's the problem. How do you determine who's similarly situated?
We leave that to you.
I'm sorry.
We leave that to you, because you're ACS.
No, I think what happens is, and this is why class certification fails, because you can't even figure out who is a class member unless you look at their individual situation.
Well, maybe I missed it, but can't you determine who's a foster child and then if that foster child is entitled to specialized services, can't you then decide either it's your responsibility to provide it or OMRDD's responsibility to provide it, regardless of the name of the child, any child in that class of individuals?
Well, at a certain point, it becomes OMRDD's responsibility. But even when you look at the interveners that we have here, there are several that are waiting or were waiting to be placed by OMRDD, and while they were waiting to be placed, ACS continued to provide them services as an exception to policy. So it's not as though they...
What does the city pay for and what does the state pay for? If they go into a state-operated residential facility, then the state bears the cost, and if they can get Medicaid coverage for that, they seek it?
I think that's the case, Your Honor, but
And community residences, who pays for that? The city would pay if they're in a community residence in the city, or does the state pay part of that?
The city pays if they are still within ACS's care, and the state pays once they move over into OMRDD's care.
So that's what this dispute is between the two agencies, I take it, is who's going to pay for this class of individuals.
And when the state becomes responsible to take over from the city.
And why do you resist intervention by the people who would be most affected by the results of this litigation between you and the state?
Okay. We are not resisting intervention. What we're saying is that the class as it was defined by the interveners and the way that the class definition was accepted by a state Supreme Court is unworkable. We're not saying that there's no possibility that a class can't be certifiable. One of the problems, of course, here is that nobody has pointed to a specific statute or regulation that we have violated. They're making generalized statements, but they can't point to any specific. As a matter of fact, the question arose as to whether or not a court could order training. Sure, a court could order training, but the problem basically is that you can't point to a specific regulation within the statutes that discusses training that you can say that we haven't met.
Tactically or strategically, why wouldn't you want them on your side? I mean, you sued OMRDD saying that they're not doing their job, right? So why wouldn't you bring these people in and say, here's Exhibits A through 150?
In a workable class, I can understand that being the case, but what we're saying is that the class as certified is unworkable.
But can't that certification always be reviewed and modified as the case moves along if it proves to be unwieldy or inappropriate?
Well, we would respectfully submit that if that was going to be the case, then the class shouldn't be certified in the first place, and maybe this court could remand it back for, the Supreme Court to determine what a workable class would be. But the answer is not to certify an unworkable class.
All right. Thank you, counsel.
Thank you.